ready to roll?
I am indeed.
Fantastic. So thank you very much again, everybody, for attending. It's fantastic to see such a lovely turnout. Thank you very much to the Community Schemes Ombud Service, Johlene in particular. I know that you are probably one of the busiest ladies that I know. So thank you so much for involving TVDM Consultants and our database of clients and colleagues to this session. I, for one, and I know I can speak for Nicole, is very, very, very excited about this topic. We've both read that practice directive over and over and over again, and we have some questions, which I'm sure the rest of the audience do as well. So before I get going on that, just a reminder to everybody that has just joined, keep yourselves on mute. And then, of course, if you've got a question, please pop it into the chat function. But other than that, Johlene, over to you. Thank you so much.
Thank you very much, Zelinda. Thank you for you and your team, Nicole. I appreciate it. Thank you for allowing the CSOS this platform. We are very excited. We have been working on this practice directive for quite a while. It took about a couple of months for it to be board approved. As you know, state-owned entities, nothing happens overnight. So just to give a bit of background, my name is Johlene Wasserman. I've been with the CSOS for 6.5 years. Love it, hate it, all at the same time. I'm the acting executive for governance, compliance, enforcement, and training, and I'm going to take you through this practice directive. As Linda said, the CSOS would like to engage with you, our valuable stakeholders. My email is always available. My telephone number is available. Call me. You know, as Linda said, you know, go through her if you would like. But our doors open at the CSOS. We just moved offices, head office to Centurion. We're no longer in Sandton. So if you are around, come and pop us a visit. And if there's time afterwards, Zelinda, of course, I would like to take the stakeholders through the business units and the protocol as to who to phone for what information. I'm sure that sometimes there is frustration to say we can't get hold of this person or that person at the CSOS, you know. So if there is time, the practice directive will probably take half an hour to go through. I'm not going to take any more time. I'm going to stop my video and then I'm going to start sharing the practice directive presentation that I've prepared for you today. Thanks. Share screen. I'm just going to make it big. Zelinda, you'll tell me when everyone can see it.
Yes, everyone can see it.
Thank you. And I'm going to proceed. Zelinda, just that you will admit everyone.
Yes, correct.
I don't have to worry about it.
Don't worry about it.
Here we go. All right. Oh, goody. Now this thing. Oh, right. Let me put it there. All right. So many people say, but the CSOS, you're not authorized to make practice directives. Yes, we are. In terms of Section 36 of the CSOS Act. So what I always say, I don't give legal advice. We give legislative advice. We can only advise on what the legislation says at the end of the day, because we are a state-owned entity and we work through our legislation. We have no other powers. So in terms of Section 36 of the CSOS Act, this section allows the CSOS to make practice directives relating to the operations of the CSOS. And hence we have amended the practice directive for rules, because as you know, ladies and gentlemen, that it's very important for the CSOS to now, why isn't it sliding? Oh, apologies, it's just me. As you know, in terms of the CSOS Act and the regulations, is that all management and conduct rules must be quality assured by the CSOS. And we have to issue that Section 10(5)(c) compliance certificate in order for the management and the conduct rules of the community scheme of the sectional title development to be enforceable against the members. So that's very, very important. I've written numerous articles on this. So Linda, I can share our quarterly newsletter with you and the stakeholders. I'm not sure if everyone is receiving it. It's on our website. However, our training department can send it to everyone. We have a packed a newsletter full of information, articles, and one of the articles I wrote is the fact that the management conduct rules are not enforceable if they are not quality assured and a compliance certificate issued by the CSOS. And this is for sectional title developments currently. So basically, we have compiled a list at the CSOS of all the rules that is deemed undesirable in terms of the constitution of our country, or in terms of transgression, or, well, a contravention rather, of the Sectional Title Schemes Management Act. So I'm going to take you through the new additions to this practice directive. As I said, it must be quality assured by the CSOS. You will receive a compliance certificate for that specific scheme. And then, very important, we have added that you, either the managing agent and or the board of trustees, must send it to everyone in the community scheme within 7 days after the CSOS gave you your stamped rules back and your Section 10 certificate. It's very important that you must get your Section 10 certificate as well as your stamped conduct or management rules. It must be stamped on each and every page. If it's not stamped on each and every page, please bombard me with your emails. We will immediately get it done for you. And that's a fault on the part of CSOS then. As I mentioned, it's not enforceable if you do not have that Section 10 certificate. All right, we have moved offices, and we also have regional offices, ladies and gentlemen. We have open offices in the Eastern Cape as well as in the Free State. So if you ask us to send your Section 10 certificate, the original, to one of our offices in KZN, Western Cape, Eastern Cape, Free State, we will gladly do so, and then you can pick it up at our CSOS offices there. Right, as we've mentioned, that Section 10, that the Section 10 certificate is now being issued. It must be kept in mind, ladies and gentlemen, that if you submit management and conduct rules to the CSOS, and it states that it's Section 35(2)(b) of the Sectional Titles Act, we're going to send it back to you because it must read Section 10(2)(b) of the STM SMA. That provision has been amended. So it just takes time for the CSOS to go over this and amend it on your behalf. So just please advise your community schemes of that. If reference is made to the Sectional Titles Act and there has been a provision that's been amended in the STM SMA, please mention it. It's very frustrating receiving rules. I do quality assurance as well to get these rules, and everything refers to the Sectional Titles Act. It takes way longer than anticipated. No longer being submitted to the deeds offices, as you know, it now needs to come to the CSOS. Exciting aspect, what's happening here is we are retrieving 150,000 documents this year from the deeds offices nationwide back to the CSOS offices because we are the custodians of all scheme governance documentation. Another important aspect, a special resolution cannot be passed at a trustees meeting. We often find this, yes, but the trustees will have a special resolution. There's no such thing. Now we come to the 28 undesirable rules, ladies and gentlemen. And I think the first one that we would like to see in your conduct rules and is now compulsory is the fine and penalty clause. And this is to protect each and every member and occupier within the community scheme, the board of trustees, and also make your job much easier if you are a managing agent. So fines and penalties, this was in the old rules as well. The directive may not be equal to a more than the applicable monthly levy of the owner of the unit concerned. I think that is straightforward. Then we often see that the trustees do not have any power to decide on fines and penalties on their own or to take any action against an owner or occupier. The fair and equitable procedure set out in the rules must have been followed. And then we gave an example of what we would like to see in a fine and penalty provision. First transgression notice, you can never fine a member or occupier for a first transgression. You must explain the transgression to him or her. You must advise them to stop it immediately or to stop it within 7 days. We leave that up to you to decide. the time frame of when do you want him or her to stop with the transgression. The member or occupier may dispute the offense. So what we're looking for here is an internal dispute mechanism in the community scheme. Meet with the Board of Trustees, state your case. The Board of Trustees will provide evidence and say, Johlene, you have transgressed rule number 1. You've been littering on the common property. And yeah, but how do you know that? But here is your cigarette butt. Here is your beer bottle. You know, so yes, I apologize. Don't do it again, or no, I'm not accepting it. Well, Johlene, we've got the evidence. Here's your warning letter. Second transgression of the same offense. So littering again. Then you say, but Johlene, again, you've littered, same offense, first offense. Tell me to stop. When must I stop? Take me through the internal dispute process, meet with the trustees, and then you can start fining the individual. However, we've not stated the rand value of the fine because we do leave that in the hands of the community schemes, and we do not want to over-regulate the industry with that. All we're asking, that's not more than a monthly levy. And must be fair, of course. Littering. Now, these are actual rules that keeps on popping up in conduct rules. Hence, we've placed it in our undesirable rules. A rule stating that owners and tenants or occupiers are not allowed to eat on the common property. It's bizarre. Insurance. When a tenant or occupier amends their personal insurance policy or taken over movable property or their car insurance, the trustee should be notified. We cannot see any reason why this should be. Enforcement of management and conduct rules. Management Rule 71 has been repealed. That relates to private arbitration. As you know, the CSOS is an avenue to come to for a dispute, or the courts of law. We are currently amending the CSOS legislation to actually state that the first instance you should knock on the door of the CSOS as opposed to going to court, because it is more expensive and we are much cheaper and quicker. Hope we still are. Then, of course, I've discussed the internal dispute resolution process for owners, and this must be followed prior to coming to the CSOS. So if we see private arbitration in the rules, we're going to call you out for it, and we would like you to please amend it. Contravention of rules and laws. Very, very often we see, if you transgress these rules, you will be liable for costs on charges between attorney and client scale. As far as we understand, this is contrary to prescribed management rule 24.4 in Annex 1 of the STM SMA, which states that a member is liable or must pay to the body corporate all reasonable legal costs and disbursements as taxed or agreed by the member, incurred by the body corporate in the collection of arrear contributions or any other arrangement due and owing by such member to the body corporate, and enforcing the rules. So this is obviously to protect, this is to protect everyone within the community scheme at the end of the day. All these rules, not just this one. Yeah. Domestic employees, this is actually I always take this in line with me. I'm an employee of the CSOS, and I can imagine if this is in my employment contract that I'm not allowed to receive visitors, I'm not allowed to talk to anyone, I'm not allowed to loiter or walk on the common property, I must wear my name tag at all times, and I must go through the side entrance, can't go through the main gate, or anything like that. It's derogatory, it's discriminatory against domestic workers. Reword your wording. It reminds us on the scheme governance officers at CSOS always states, it reminds them of the pas, the dompas people had to wear in the apartheid era. So these words, it's very harsh, and we're not going to accept rules if it's got these wording in it. Duty of unit owners. Owners and occupiers requested to advise the trustees or where their mortgage bonds are at, or if there's any mortgage bonds or in a company or anything like that. you know, with the new POPI legislation coming out now, as we know, well, that came out in terms of Chapter 3, we are appointing someone in the community scheme, and they must now have a big database of everything happening within the community scheme. So it's no need for this rule to be in here. It's covered by the POPI legislation. You know, so, but to put it in a conduct rule, it serves no purpose. Outside security gates, burglar bars, canopies are situated on the common property and is the responsibility of unit owners. This is not correct, as it's the responsibility of the body corporate for maintenance and repair. Jesus. What we like to see here, and we often are misunderstood here, is that we would like to emphasize here that immediately when there's a geyser claim, that excess is for that member, you know, that homeowner. That is an uninsured amount, an excess amount. We all have to pay it on our cars, on you know, on our home contents, as well as on our geysers. And then, of course, we would like to see that there's drip trays. That is obviously, that's a mitigating factor, that mitigating our risk with geysers. So a drip tray, we would also like to see that placed underneath the geysers, but the excess must be paid by the homeowner. And before members lodge complaints with the CSOS, please tell them to come to me. I'll give them legislative advice and the provision advising that they have to pay the excess. We could receive a lot of complaints at the CSOS. Say, but why must I pay your excess? But it's in the prescribed management rules. Tenant evictions, we often find it. If the tenant is transgressing this rule, he will be evicted because these rules stand. Now, that's unconstitutional. It's against the Constitution. Only the High Court can evict a person. You cannot have it in your conduct rules. Vehicles will be towed. We have put this one in enough, and I've bolded here, as we often find, yes, your vehicle will be towed. And I do understand, the CSOS understands the fact that vehicles been standing there for 3 years illegally, blocking everyone's path. We do understand that, but now Johlene comes back, but you've scratched my vehicle. You have to pay for it. You are liable for Mr. or Mrs. Trustee. So we say rather fine and place a penalty on this a member or occupier regarding towing. So please take that out of the conduct rules. Slaughtering. You're allowed to slaughter for cultural and religious purposes in terms of the Constitution. It's not CSOS that's saying that. And the Constitution is the highest order in the country. However, there is terms and conditions regarding slaughtering that you have to adhere to. Otherwise, a penalty will be imposed on you. You must give at least 2 weeks written notice of this, when the slaughtering will take place, the time and date, type of animal, who will slaughter it, how the animal will be slaughtered, when will the animal be brought on the premises, when will the carcass be removed from the premises, a notice from the local authority advising that this is for cultural or religious slaughtering in terms of the bylaws. It goes on that the SPCA, there must be a certificate from the SPCA, and that an official from the SPCA will be present, that the animal must not suffer. You must give notice to all the units around you. And then, of course, as I said, you will be penalized if these conditions are not met at the end of the day. Rule created exclusive use area. We often see that there might be a misunderstanding or not clarity regarding EUAs. People think if there's 5 members in a community scheme, and then we can just draft a plan and say Johlene gets garden 1, Linda gets garden 5, Johlene gets parking 1 relating to garden 1. We draft a sketch and we attach it to the conduct or the management rules. That is not so. You need to do a plan to scale, must be drafted by an architect or draftsman. Very important. You may not let the exclusive use area without the permission of the written permission of the trustees. They may not withhold it unreasonably. And then owners are responsible for the repair and maintenance. Well, we specifically said flower bed, oil spills, of the exclusive use area, including the maintenance and repair of any water pipes, electrical wiring, downpipes, security devices, lapas, verandas, and the likes of. We often have a question, yes, but why must I repair the exclusive use area? That's been created via the rules for me if the contractor uses it once a month to come and check pipe on the common property, servicing all the owners. So that's, ma'am, that's still your exclusive use area. Business activities, you can't use the section or exclusive use area for any other purpose than what's intended to, unless you have the written consent of all the members. DSTV and solar panel installations, we often see your dish may be installed by an expert. What expert are we talking about here? Please specify it in your rules, a DSTV certified professional installer. Estate agents, only a certain estate agent may come and sell my property. It's discriminatory, it's unreasonable, it's prejudicial to unit owners. It's an unreasonable limitation on the rights of owners to pick which estate may sell your unit. Language policy, we often find in the old management and conduct rules that it's in Afrikaans, and the CSOS quality assures Afrikaans rules, of course. However, then we find that those rules are sent to potential buyers or members that already bought, people that already bought into community scheme. It's only in Afrikaans, and they don't understand it, and they say, well, all meetings will also be held in Afrikaans. That is difficult because we understand that we have all the right to speak our own language, but the business language is English. So if we can say that, please have your management and conduct rules in both English and in Afrikaans. Developers, you'll often find this in a homeowners association, but we've seen it in sectional title, scheme rules, management rules. The development period must have years of the estimated period of when the urban are all sold, when the period or when the urban are sold, whichever comes first. Please specify this. This is a new development. Domicile, we often find in the rules, it states, well, your domicilium must be this community scheme. It cannot be any other address. What if it's an investment property? What if you rent out the property? Surely that can't be your address of choice. Alterations inside the unit. You can make alterations inside your unit as long as it does not affect the structural integrity of the section or the scheme as a whole. And then I would like to place emphasis on Section 5H of this Sectional Title Schemes Management Act, read with Section 24 of the Sectional Titles Act. We often find in the conduct rules it says, well, we have now repealed these provisions, and these are the new provisions as per the conduct rules of Mill Park News. That cannot be, that's legislation. You cannot amend it. It is, that is the law. Location of pipes. Trustees must ensure that they have in their reports of the body corporate plan showing the locations of the pipes, wires, the cables. This is in terms of Section 3(1)R of the SMA. New schemes must request these records from the developer, and existing schemes must approach the local authorities for it. Animals and pets. A very, very sensitive and emotional topic. You're either a pet lover or you're neutral about it, or you dislike pets, and that's your right to do so. The scheme may prohibit pets entirely and say no pets are allowed. However, please keep in mind that a medical assistance or guide dog in terms of prescribed conduct rule 1 is allowed, but now we often find this is being abused, and we receive numerous complaints or dispute applications stating that this is my medical assistance doc, this is my therapy doc. You need a report from a psychiatrist or a doctor advising this is your medical condition and this animal is trained to assist you with this therapy. I know of one matter. It's been in the newspaper, I think, a number of years ago, that this little girl has asthma, and her dog, when she can't find her asthma pump, the dog finds it for her. It's a medical assistant dog, you know, that is obviously needed, and it's absolutely the CSOS would absolutely grant such an application if that is the instance. However, I do think you need to advise your clients and members of community schemes that it's not just the CSOS will approve or make an adjudication order where there's a medical assistance dog and says, well, this dog is, on my opinion, this is my medical assistance dog. No, that's not how it works. And then, of course, we are very strong about this rule. Karen and myself has had numerous training sessions on the no animal rule, where it states that, well, no more animals, and then please remove all the animals as 7 days as from date you're off from the community scheme. That would never be, and the CSOS will not grant it, because that pet must pass away and then it cannot be replaced. That is what meant with this provision. Not if it's a no animal rule, remove all animals from the premises. And we've also not specified what can be kept as a pet. Some individuals have cats, some have dogs. We're not stating you can only have a dog, or not only have a cat or a snake or a rabbit, or whichever your pet may be at the end of the day. Governance and management issues. Managing agents must make all audited financials available to the member, especially if the trustees have signed them off. An electronic copy can be made available, and of course a fee may be charged, because more often than not we find out that members of community schemes say, well, managing agent 1 is not giving it to us. Well, if they want, they're charging me for it. Yes, sir, yes, ma'am, they do not work for free and they're going to charge it. Please ensure that that charge is in your service level agreement if you are a managing agent. Trustees' fiduciary duty. This is another point of it's problematic at the CSOS. As trustees change hands every year, as we know, after the meeting. New board of trustees comes on, and there was no proper handover from the previous board of trustees, and they said, well, it's not my problem anymore, I had enough. You are the new trustees, you deal with it. Not so. You need to assist them and give a proper handover, and you are required to respond and assist the current trustees if there is allegations against them and the complaint is lodged with the CSOS. Election of trustee. You may nominate any person to stand for the office of trustee, a tenant, or a third party. And there's obviously a subject to disqualifications. And we often find that people say, but what? Johlene is a trustee, but she's not paying her levies. Yes, Johlene can stand as a trustee member. How? Because the prescribed management rules state that only a court of law or an adjudication order may state that I may no longer be a trustee because of me being arrears with my levies. Proxies. Member may appoint a proxy to represent them at a meeting. This can be anybody. This is Form C. It's attached to our regulations. You may not be a proxy for more than 2 members, not units. People often confuse that. So just keep that in mind. And then obviously the normal prescriptions of the PMRs will apply to proxies. Co-owners needs to give the one or the other. That's standard. Mandate of trustees. Please place on the trustees restrictions or set limits of the money they can spend if you so wish to. Trustees' activities must obviously be transparent and recorded in writing. Members are permitted to access these records of the meeting, however, they may not vote at the trustees' meetings. And please keep in mind that we do know it's difficult to be a trustee, and it's a thankless job. And we do, and we feel very strongly about it. Johlene is always a troublemaker. She always is disturbs these meetings, you are allowed to tell me to leave. And the CSOS will endorse that, because we do understand members sometimes and how they act towards trustees or the managing agents. Interest. Yes, interest can be charged at the discretion of the trustees. And that's prescribed management rules 21 that says that. That's fine, but it can't be more than 24% per annum capitalized monthly in arrears. So if we do get these complaints, before we actually get these complaints, we try to give them legislative advice to say, but hang on, your trustees can charge it. You know, there's no need to lodge a complaint against them or the managing agent, because it's in the legislation, and we point them to that legislation. Levies. There can be no rules preventing members from exercising their voting rights for non-payment of levies, or preventing you access to the complex for non-payment of your levies. There's also case law in that regard, and I will be happy to send it to you if you pop me an email. We are nearly done, ladies and gentlemen. 2 more rules. Costs. The CSOS is not going to reimburse you for your costs, your lunch money, your petrol money, or the dispute resolution fee. If you lodge a dispute with the CSOS and you've been successful, or you've not been successful in that matter, that's for your own costs. Just a heads up, managing agents, if there's managing agents here today, please put in your service level agreement the costs that will be incurred by the community scheme, your client, if you do travel to the CSOS or attend CSOS hearings. And then lastly, very important, disconnection of electricity and water. This is against the Constitution. You can't disconnect my water and electricity if I do not pay my levies or I'm in arrear with my levies. The CSOS will reinstate that water and electricity within 48 hours, and that bill will go for the community scheme for the reconnecting fees. Ladies and gentlemen, that's that from my side. Thank you very much. That is my contact details. As Zelinda also mentioned, I'm going to send you this slideshow. The practice directive is on our website. I can send it to you. Zelinda, I'm sure, send it to you. And that is my details. If I'm not available on my cell phone, it is currently ringing. It's because I'm talking to you. I do try to phone back, but however, if you can pop me an email, that's actually better. And that's that. Thank you. Thank you very much. Thank you, Zelinda.
Fantastic. Thank you so much, Johlene. Johlene, you wanted to perhaps talk to the members about the different channels of communication. Perhaps you can do that now, and then we'll take some questions.
That's I can do that, Zelinda. It's not going to take long. I just want to stop sharing this, and I'm going to share another presentation. It's regarding the business units in the CSOS, because I see there's perhaps a challenge to say, well, I can't get hold of Johlene or this one or that one. Can everybody see this?
Yes.
Thank you. Okay, I'm not going, this is our legislation. I'm not going to take you through it. That's fine. I just would like to emphasize all the red is compulsory at the CSOS. The registration of a community scheme, every community scheme in South Africa should register. It's law, and we have commenced with compliance and enforcement. So if you've received a strict letter from our Chief Ombud Advocate Boyce McKees, it's because you've not been complying with the CSOS. Everyone must lodge annual returns. And then, of course, every sectional title must lodge their conduct and management rules. Then, of course, there is additional services that we offer. A Section 69 resolution, if you cannot pass a unanimous or special resolution in your complex, CSOS can assist you with that. Of course, anybody can apply for a waiver. Please apply for a waiver. That takes away your CSOS levies and your dispute resolution fees if you qualify. I can send you that practice directive. Everybody should apply for a waiver if they meet the criteria. Please do so. We train everyone. We train you, our stakeholders, owners, developers, members, trustees, occupiers, managing agents. We train core staff, conciliators, adjudicators, and we do this for free. We do not charge you to train you. You're already paying your CSOS levy, and that's a service we provide you. And obviously, if you amend your community scheme particulars, please fill in the form. I'm going to take you through all the forms. We do receive correspondence weekly from IRBA, the auditing regulator of non-compliant body corporates, HOAs, share blocks. Be aware, members, we are in the process of writing to you if you've not done that already. Exciting news, Zerlinda and stakeholders. We are going to re-advertise for the panel of executive managing agents. Zerlinda, I'm going to send it to you guys. It's going live on the 16th of May in the newspaper. I'm going to send it to you on Monday. We're looking for a panel. There's criteria in there. If you meet that criteria on our panel. So what that means, if it's Mill Park Muse Body Corporate, nobody wants to be trustees, and you can't find a managing agent that you would like to appoint as a, as an executive managing agent. You come to the CSOS and we give you a list of all executive managing agents in your region, in South Africa, which you can pick from. And rest assured, they are all then compliant in terms of the CSOS's terms and conditions. So that's very exciting. We will also do obviously training on that. We have currently drafted a code of conduct for the panel of executive managing agents. We're going to get that board approved by the end of Q1, and then we're going to send it to everyone. We are currently amending our CSOS Act and regulations, the SMSMA Act and regulations. And then, of course, if you are an administrator for a body corporate, you need to send us your Section 16 reports. We have a database of all administrators' reports. However, we've seen some administrators not sending that to the CSOS. Please send that through to the CSOS. It's not like we have neglected it. We've just not spoken about it that often. That I've discussed, very important. You must pay your CSOS levy and fee, must maintain the fidelity insurance. I've spoken about the others. Oh, directives we have done. We are currently having a waiver directive, rules I've just discussed with you, special unanimous resolution, new one coming out end of Q1. What's new also coming out at the end of Q1, registration of a community scheme, annual returns, compliance and enforcement, and opening of a sectional title bank account. That's all practice directives that you will see at the beginning of July. Here's all the forms, ladies and gentlemen. We often see that, I'm not sure which form to fill in. This is the form. CS1 for registration, amendment to CS1A. That's amendment of trustees or managing agent particulars. If it's changed, you must notify the CSOS of it. Waiver, we have one for individuals as well as community schemes. Resolution, special unanimous, rules. Just to stop there, we only have one form, Form B. That's the amendment of rules. Even if you've not amended your rules, that's the only form to fill in. Annual return, CS2, access to information, CSR, it's R8 a copy, and the dispute resolution form is ADR. This is the email addresses. That's all part of my unit. You'll find that we have limited the number of emails, inboxes. Sectional title goes for rule amendments, special and unanimous resolution, and access to information. Then the waiver inbox has got its own inbox, the training has got its own inbox, registration and amendment of scheme particulars has got the registration inbox, and then we've created a new one for homeowners associations, HOA governance at csos.org.za. That's also managed by, well, all the inboxes are managed by myself. They all got automated replies with my contact detail and my email address, because we do not want our stakeholders to say, well, can't get hold of you, CSOS. This is the colleagues of the governance business unit. These telephones are all working. I've tested it yesterday again. This is a direct line to these colleagues in the governance, compliance, enforcement, training business unit. Gift and Pamela are the administrators. They allocate the rules and the resolutions. That's their direct line. They share a telephone, they sit at the same desk. Marandeni is one of our attorneys that quality assures the rule. That's her direct line. Edward is still working from home. However, you can contact me if you've not received a response from Edward. Perhaps some of you will remember Latin Tavi Singh and Rissi. was part of scheme governance. However, they have been promoted to compliance and enforcement business unit, and they're sending all the letters out if your scheme is non-compliant with the CSOS regulations and act. And Glenda is the administrator, all direct lines. Then Dennis works with waivers, registrations and amendment of particulars. The same with Trotsky, the same with Dikeledi. I don't expect you to know this. You don't have to phone them. You can just pop me an email. However, if you would like to have information directly, and they can probably give it to you faster than what I can, you phone them, and the email addresses I can also forward you, of course. Annual returns, we have Basira, Brian, and Musa. They are accountants. They're going through the audited financials, see that all the annual returns are filed, as well as the IRBA correspondence. And then Kanya Seelish, attorney, she also does this scheme governance rules and resolutions. Then Vuyiswa is our training and education officer. All your training needs, you can either contact her or email her. And then for the rest, everything else, panel of executive managing agents, training, legislation, anything else. Well, anything really, you can contact me on my cell phone. I also have a business telephone. I can give it to you. I don't know why I didn't put it here, but you can always email me. And then, colleagues, I do not have it in the slides, Linda, very quickly. The ombuds. We have Malatatsi Votini in the Western Cape. She serves all the Cape provinces. Then we got A.B. Masilu. He serves Gauteng, Limpopo, and Northwest. Then we got Mervyn Dorisami, Free State, KZN, and Mpumalanga. But we have an adjudicator general, Kanosi Matlotla. I'm not sure if you guys are aware of this. That is the lines of reporting. So if the complaints manager, Charmaine Johnstone, does not respond, you send it to the ombud in that province. If not, you send it to Kanosi and Zelinda. I can provide you with their details, as well as cell phone numbers. We all have business telephone numbers from managers and executives, and we can give you that. And that's that from my side. Thank you very much. And apologies if I've taken too long.
No worries. Thank you so much, Johlene. You're so energetic in your presentation. I was with you every single step of the way. We've had quite a few requests for a copy of the slides. Obviously, the slides as well as the audio is going to be made available because this meeting is being recorded. But Johlene, if you perhaps could just send a copy of the slides to me and I'll distribute it to everybody, as well as any other contact information that you mentioned that wasn't on the slides. People have posed a couple of questions. Obviously, we can't get through all of them, but I'm going to just raise them with you, Johlene, and obviously answer them as far as you're able to. If not, that's 100% fine as well. So the first question is, does the amount of the fine not being higher than the monthly levy apply to HOAs and POAs? So what is the CSOS ruling when it comes to homeowners associations and property owners associations?
Thank you so much for that question. I neglected to mention that I'm currently busy with the practice directive for homeowners association. That would come at POAs, homeowners, whether it's common law or non-profit companies. We're going to make a list of undesirable rules for you guys. It will be out in the beginning of July.
Fantastic. There's another question, well, there were actually a couple of them. When you mentioned the legal fees and the recovery of charges, does that mean that the body corporate cannot change the management rule to provide, as per the old act, that legal fees could be recovered from the owner?
Yeah, you see, that's the thing, but because that extract that I've put in the conduct rules, in our undesirable rules, we find that in the rule self of the complexes, you know. So it's very problematic, but it's one-sided. It says, well, there's no option to come to the CSOS, and then automatically we're going to pound you with legal fees against attorney and client, and that's what we don't want to see at the end of the day. You know, it's that harshness, and just to say that, well, there's no other recourse, and it's, look, the CSOS Act has not been amended. You can either come to the CSOS or you're entitled to go to your attorney of choice to have that real levies collected. Absolutely, but just do find that the courts are referring it back to the CSOS, because we are the regulator and we have the same amount. well, all our orders are enforced through the High Court, and we have a legislation behind our name. So I think that is the importance of it, not to restrict members of not doing that, but the fact is only to say we're going to the court and that's final.
Thank you. There's another question as to how is the maximum interest determined?
It's in terms of the National Credit Act. I think I've added it to the Undesirable Rules as well. That 24% that's what the NCA, that's what they are limiting it to, and that's what we have been going through. So anything that trustees can, of course, decide up into that amount.
I know this is quite a prevalent question, and Willie almost jumped out of his chair there. Willie, do you want to just comment on that? I know it was your question. We can't hear you, Willie. Well, Willie's just getting his audio right there. Just another.
Yeah, sorry about that.
All right, no problem, Willie. Over to you.
Hi, thanks, Zelinda. Johlene, the Act specifically, or the rules state that the maximum interest rate does not exceed the maximum in terms of the Credit Act, but it does not say what portion of the National Credit Act. And then we had case law that specifically said that levies are not incidental credit. So to say that it's 24%, that is just picking one of the sections of the Credit Act above other sections of the Credit Act. So there's no specifics in the rules. So that needs to be changed. So I'm happy. I mean, I think that is the general trend in the industry, that it's charged at 2% per month. And I don't think that that's a problem. But as it stands at the moment, it does not actually mean that, because we can't just pick any section of the National Credit Act. I mean, is it now unsecured lending? Is it payday loans? What portion do we pick? We can't just pick anything.
Can I comment?
Sure.
Thanks for that, Willie. That is a valid point, and I'm going to look into that. I hear completely what you say. And can I engage with you offline regarding this, and we can have a chat, Zelinda? Sure. That's very interesting, and it's very important for the CSOS, to have these types of engagements. So it's valid points being raised. So, Willie, can I get back to you on that?
Sure.
And can we have a discussion regarding that?
Sure, Johlene, that would be great. I mean, those are one of 3 or 4 points that I've raised that we have problems in the legislation with, that we need to look at to see if we can't change that, because there are not certainty in respect of those points. So that would be great to have those discussions.
Thanks. And Zelinda, if we do, go out to our stakeholders with our amendment of legislation, I've mentioned this to you previously, it would be vital to have such a session as well for an hour or two to see the industry comments. We have received a few, but obviously not all of them, because obviously it's a lengthy process to amend legislation. It takes about 5 years. So we want to get it right first time. Thank you.
Definitely. So perhaps you and Willie could have a conversation before Stratafin's webinar on Thursday the 20th at 11 o'clock, and perhaps we could just make a comment or two about that at that point in time. This is an interesting question. Are all disputes heard? In other words, everything that is submitted, is it heard? Or does the CSOS consider the merits of this disputes before putting it forward to conciliation?
Oh, very good question. So, as everybody knows, well, I don't know if you know, I worked in disputes for 4 years before I moved to governance. Yes, how it works is each and every application must be quality assured by the provincial ombud and or the complaints manager, but the provincial ombud must sign it off to say this is going forward in terms of section 39(1) to 7. So not everything can go through because we don't have a mandate for it. Purely legislative advice can be granted. Sometimes you'll see people fill in a application form, but they only need advice from the CSOS. So hopefully not everything goes through. Everything must go through. That's in terms of section 39(1) to 7. And then, of course, the CSOS is passionate that at mediation or conciliation at that fact, 80% of disputes must be settled. And then only the 20% goes through to adjudication. So not everything will reach conciliation or adjudication. I hope I answered that question.
Fantastic, thank you. There was a question as to the appointment of a panel of executive managing agents. And I suppose more information will be available, as you said, on Monday. But is this regulation or guideline going to deal with who can be executive managing agents and what they can charge? Would it restrict what they can charge or give guidance as to what they can charge?
Good question. It's in my code of conduct I drafted. We only state that must be a fee. You know, we are not going to state what you as managing agent or company should charge the community scheme. That is up to you. But more information on Monday. I'm going to send it to Zerlinda, and please apply for, we're not limiting the amount that should be on the panel, the number of companies that should be on the panel or individuals at all.
Okay. Are you able to comment, Johlene, as to the roundabout timeline for the issuing of a certificate of approval for rules, both in the case of new schemes as well as existing schemes, please?
Yes, it's a challenge in our division as we are understaffed. However, an advert is going out to appoint 2 new scheme governance documentation officers. As I said, we're currently 5 people quality assuring the rules. Turnaround time for new schemes can be anything from 1 day. If it's urgent, it needs to be lodged up into a week's time. 30 days max to quality assure your rules. So if, ladies and gentlemen, your rules is over 30 days, you've not heard anything from the CSOS, you're going to send me a very strict email, and I'm going to make sure it gets done very soon.
Fantastic. You mustn't be scared to send Johlene a strict email. I do it all the time, and she still smiles at me whenever she sees me, so there's no hard feelings. There's another question as to this guideline for an executive managing agent, but in this case, in regard to administrators, would it be something that the CSOS would look at to have a panel of administrators appointed as well?
I love these questions. Yes, yes, yes. After the panel of executive managing agents, we're going to do a panel of administrators. We're already having discussions regarding that. We are already looking into it. So definitely we're going definitely to have a panel of administrators.
Okay, fantastic. And then the amendments to the legislation that you mentioned that you're busy working on, is there going to be any type of public participation or a draft circulated? And when
yes, we are. I have completed the draft and I've handed it over to legal, whereafter, when we've cleaned up the draft, we're going to have public participation on as many platforms as we can, and we're going to present that memo to the stakeholders, and they can then comment on it.
Okay, fantastic. There are quite a few questions that came in. Another one, I think we've got 1 or 2 minutes, is when will the next round of training take place, province per province?
Yes, we do train. We do the YouTube videos. We do articles in our newsletters. We would like to do contact training because it's really not the same if you train online. But contact training, hopefully July, August, we're going to start, well, not with Gauteng this time. We're going to start KZN, Eastern Cape and Western Cape. However, just on that point, if I may, Zelinda, the CSOS provides training on an ad hoc basis to community schemes. Anything you would like to know about, we do AGMs. We attend AGMs for schemes that, or managing agents that, or trustees that ask SATSU, and it's no cost for anyone.
Fantastic.
So just pop us an email.
Great stuff. So, ladies and gentlemen, there were a couple of more questions, and what I'll do is I'll ask Johlene offline if I can share all the questions with her, and if we can put together a Q&A to be circulated to everybody, if that's possible. Quite a few of the questions, although pertinent, is not relevant to today's topic. And my partner, Nicole Tavares, will most certainly kick me under the table if I don't use this opportunity to punt a little bit of TVDM business and say that firstly, thank you so much, Johlene, for this very, very exciting and informative topic and presentation, and for allowing us the opportunity to share it with everybody. As specialist sectional title, homeowners association attorneys, and all that fun stuff, we do work with trustees to change rules, amend rules, constitutions, memorandums of incorporation. So if you've got any questions in that regard or need the assistance, please do contact us. But thank you so much for your time. Just a reminder, this recording will be made available on our website. If you have any questions, please do pop us an email, and Johlene, I'll be in contact with you to get any other information as well as the slides and things like that. But thank you very much for your time. All right, everybody, thank you very much. Have a lovely day further with 1 minute to spare. Have a fantastic day. Keep well.